Hashtag how to read a contract. Essential legal knowledge. Most people sign contracts without reading them. Studies suggest that nearly 90% of people agree to terms and conditions without reviewing a single word. And while clicking through a software agreement might feel harmless, the same habit applied to a lease, an employment contract, or a business deal can cost you thousands of dollars, your rights, and sometimes years of legal headaches. The truth is, reading a contract is a skill, and like any skill, it can be learned. Today, we are going to teach you exactly how to do it. Hashtag background. Why contracts matter more than you think. A contract is not just a formality. It is a legally binding promise, enforceable by a court of law. When you sign your name at the bottom of a document, you are agreeing that you understood its contents, accepted its terms, and will be held responsible for honoring them. Courts do not typically accept "I didn't read it" as a valid defense. In fact, the legal principle known as the objective theory of contracts holds that your outward actions, like signing, matter more than your private intentions or misunderstandings. Contracts govern nearly every significant transaction in modern life. Employment agreements define your salary, your duties, your benefits, and critically, what happens when things go wrong. Lease agreements determine not just your monthly rent, but your liability for damages, your right to sublet, and what notice your landlord must give before entering your home. Business contracts allocate risk, set timelines, and establish consequences for failure. Even a simple contractor agreement for a home renovation can contain clauses that dramatically shift financial responsibility if something goes sideways. Understanding contracts is not just for lawyers. It is essential knowledge for anyone who participates in the modern economy, which is all of us. Hashtag main content. The anatomy of a contract. Every contract, regardless of how long or complicated it appears, follows a recognizable structure. Once you understand that structure, reading any contract becomes dramatically easier. The first section you will encounter is typically the preamble or recitals. This introductory portion identifies the parties to the contract. Pay close attention here. Names matter. If you are signing as an individual versus as a representative of a business entity, the legal consequences are vastly different. Personal liability is very much on the table if your name appears without a business designation like LLC or corporation next to it. Next come the definitions. Many contracts include a definition section, sometimes labeled simply definitions or embedded throughout the document with capitalized terms. When a contract says, "the services shall mean," or "the term is defined as," it is creating its own internal dictionary. Never assume you know what a capitalized word means based on its ordinary usage. Always trace it back to its definition. Courts interpret contracts based on the specific language used, and a defined term can carry meaning far different from its everyday understanding. Following definitions, you reach the core operative provisions, the heart of the contract. This is where obligations, rights, timelines, and deliverables are described. Ask yourself 3 questions while reading this section. What am I required to do? What is the other party required to do? And what are the specific deadlines and standards for performance? Vague language here is a red flag. If a contract says a project will be completed in a reasonable time, that ambiguity can lead to genuine legal disputes. Precision protects everyone. Hashtag deep dive. The clauses that can change everything. Several specific clause types deserve extra scrutiny because they carry disproportionate legal weight. Indemnification clauses are among the most powerful and least understood provisions in any contract. When you agree to indemnify another party, you are agreeing to protect them from certain losses. Damages, or legal claims, often including the cost of their legal defense. Broad indemnification language can make you financially responsible for events that were not your fault. For example, a freelancer who signs a contract indemnifying a client against any and all claims arising from the services could theoretically be on the hook for lawsuits related to the client's own negligence. Always read indemnification clauses carefully and consider whether they are mutual or one-sided. Limitation of liability clauses work in the opposite direction. These provisions cap how much one party can recover from the other if something goes wrong. You might see language stating that a vendor's total liability shall not exceed the fees paid in the prior 3 months. If you paid $500 per month and suffered a $100,000 loss due to their failure, that clause could leave you with almost no meaningful remedy. Understanding what you are giving up before you sign is absolutely critical. Intellectual property ownership clauses are particularly vital in employment and contractor agreements. A work-for-hire provision can transfer all ownership of anything you create during an engagement, including work you thought was yours, to the hiring party. Some employment contracts go further, claiming ownership over inventions or creative works developed on your own time if they relate even loosely to the company's business. Before signing, understand exactly what intellectual property rights you are retaining and what you are surrendering. Termination clauses define how and when the contract can be ended. Look for whether termination requires cause, meaning documented failure or breach, or whether either party can terminate for any reason with advance notice. The distinction matters enormously. A contract that allows your client to terminate for convenience with 30 days' notice gives them far more flexibility than it might give you, especially if you have invested significant resources up front. Also look for what happens after termination. Are there survival clauses that keep certain obligations alive even after the contract ends? Governing law and dispute resolution clauses tell you where and how disputes will be resolved. A governing law clause specifying that all disputes will be decided under the laws of a particular state means those laws will apply even if you live somewhere else. Arbitration clauses, increasingly common in consumer and employment contracts, require you to resolve disputes through a private arbitration process rather than in court. This typically means no jury trial, limited discovery, and an arbitrator whose decision may be very difficult to appeal. Class action waivers embedded in arbitration clauses further limit your ability to join collective lawsuits. These clauses are rarely negotiable in standard agreements, but you should know they exist and what they mean. #analysis. Practical strategies for reading any contract. Knowing the structure of a contract and the dangerous clauses to watch for is the foundation. But effective contract reading also requires a practical process. Start by reading the entire document before focusing on any single section. Many contracts are internally cross-referenced, meaning a clause in Section 7 might be significantly modified by a paragraph in Section 14. Reading sequentially without understanding the full picture can cause you to misinterpret provisions that seem clear in isolation. Take note of asymmetries. Many standard form contracts are drafted by one party, usually the one with more bargaining power, and contain provisions that heavily favor the drafter. Look for obligations that apply only to you, remedies that only benefit the other side, and rights that are granted exclusively to one party. Asymmetry is not automatically illegal, but it signals that negotiation may be both possible and necessary. Pay attention to the word material. In legal contexts, a material breach is one significant enough to justify terminating the contract and potentially seeking damages. A non-material breach might entitle the other party to minor remedies but does not usually allow them to walk away entirely. When a contract defines what constitutes a material breach, it is setting boundaries around the most serious consequences. Understand those boundaries clearly. Look for automatic renewal provisions, often buried in the final pages of subscription or service agreements. These clauses renew the contract for another full term, sometimes another year, unless you provide written notice of cancellation within a narrow window, often 30 to 60 days before the current term expires. Missing that window can lock you into obligations and financial commitments you were not planning on. Finally, do not ignore the schedules, exhibits, and attachments.